good to know.
You can be seated. All right, we are reconvened in the matter of State versus Kohberger. Defendant is present together with counsel. I would note for the record that Mr. Lodson is present as well. At this point, the state is present through its attorneys. I think next we started those categories that I identified as the 9th topic. We'll continue with those and then circle back to the 8th. So let's talk about the state's concern about the grand jury not having considered the aggravating factors. Next. Mr. Logson.
Thank you, Your Honor. I apologize for not being able to be here earlier for proceedings, Judge. I overbooked myself today.
You're here, so that's fine.
Your Honor, as to the argument as to including the statutory eligibility requirements for a death case in the grand jury, I think the two major hurdles that we have to get over are, one, the Hurtado case not requiring the grand jury to apply to the states. And then the second is the ruling in Abdullah that essentially said you don't need to provide these to the grand jury.
Seemed like a good place to start.
It is a good place to start. And as we tend to do in these cases, because they are going to go up on appeal, we are, of course, asking that those things be overruled. Certainly recognize Your Honor doesn't have the ability to do that, but we respectfully make the argument that those cases were wrong. We also make the argument that there is another way to get there. So the Fifth Amendment obviously is the grand jury amendment, and I think Abdullah was looking at the Sixth Amendment or notice requirements and what needed to be included there. We furnish an additional argument that the Eighth Amendment in death cases requires additional process. And we see that largely in what occurs at the sentencing hearing, but we also see it in things like requiring counsel before it was required for anything else was required in death cases. We also see it in requiring the state of Alabama to permit a lesser included instruction so that a jury can choose something besides something that would lead to death.
Let me ask you a question about that. So on the one hand, as I understand your argument, it is that the grand jury should be required to not only find an aggravating, statutory aggravating factor, but also that the grand jury then weigh it against mitigating evidence. Is that your position?
No. Let me be clear. As we would talk about in the trifurcation motion, I'm only talking about the statutory aggravators, not the non-statutory aggravators or the mitigators. It would simply be...
Your brief says otherwise, so that's why I question that, because as we've learned, that takes a long time for those things to be developed. That's not necessarily evidence in the pocket of the state. What is now gone from a case timeline of several months to now multiple years would seem to me to even drag it out longer.
And I certainly understand that concern. I don't think that that's our position. I certainly do believe that the law would require the state to put on mitigating evidence if it had it, because that's something that they're required to do by law. They're required to put on evidence, if known to them, would possibly point in the direction that the person is innocent, et cetera. But I don't think what our position is that the state would be required to put on essentially their entire sentencing hearing in front of that grand jury. The grand jury is still only determining whether or not there is a reason to go forward with the case. Our point is that at the time of the founding, that grand jury would have known that all felonies lead to the gallows. So at that time, the grand juries were making decisions about whether or not people were going to face the death penalty. And it wasn't until the Supreme Court after Furman in the 70s that we came up with this entirely new system, but it's one where the grand jury has lost its part of its function, where it's looking at whether or not these people should be facing the death penalty or not. Essentially, they were deprived of that through the transition that was obviously intended to protect people from an arbitrary infliction of the death penalty. But the grand jury itself is supposed to also have a role in that. It's supposed to protect people from arbitrary decisions. And so that's essentially what our argument is that there should be a neutral fact finder placed between the citizen and the state when we're making the decision whether or not the death penalty should be sought. And so that is one of the reasons we're asking the court to strike the death penalty in this case. Does the court have any other questions for me? Thank you, Judge.
Your Honor, sounds like on Abdullah, this is just a issue of issue preservation, so I don't have much to comment on that. In terms of this other argument that they are saying you can look at it differently through the Eighth Amendment, keep in mind the Eighth Amendment is just the prohibition on cruel and unusual punishment. It's quite a stretch to jump from there to requirements on what needs to be presented to a grand jury. The Beck case that they cited suggests that maybe there could be a connection if that diminishes the reliability of the sentencing determination or the guilt determination, but that's not the function the grand jury plays. And so for this court to stretch the Eighth Amendment all the way back to the grand jury would be.
In fact, with respect to failings of a grand jury to pass on a particular element, for example, if there's then been a trial, the general standard on appeal is, well, the matter went to a jury and they made the determination there's proof beyond a reasonable doubt, and therefore any error is moot.
Correct, Your Honor. And I think really that gets to the heart of this claim, which is it's just kind of another way of their argument that it shouldn't be the prosecutor deciding that a notice is filed. And the U.S. Supreme Court has said it's not a problem if the prosecutor has unfettered discretion in who gets the death notice and who doesn't. So that by itself isn't a problem. So unless there are any other questions, thank you, Your Honor.
Thank you. Any rebuttal?
Well, I think it would be best to push back at least a little on the idea that the Eighth Amendment can't go back that far. I mean, recall that it was the Eighth Amendment that required that there be counsel for people that were facing the death penalty. Now, I certainly understand the idea that the Eighth Amendment's concern is that we have a reliable procedure. I certainly understand that. But the grand jury, it does fulfill some of that function as well. And besides, at least if we're speaking in terms of what was understood to have the grand jury and what it did at the time that the nation was founded, it would have been stepping in a case involving a possible death penalty and being able to put a stop to it then and there. And so I do think that the Eighth Amendment has the ability to attach even that early on, at least in cases involving death. And then I recognize that there are these cases from the Supreme Court indicating that prosecutors do not have to have anybody determine whether or not they can file the death penalty and that they can drop it out of a sense of mercy. I think that's a slightly side question to, if they choose to go forward with it, who can stand up and say, before we spend years on one of these cases, that this is not the appropriate case, someone besides the prosecutor, which is what we have with grand juries and preliminary hearings, et cetera. And so we still believe that the argument here is one that can be passed on by this court and that hasn't necessarily been ruled on by these other cases that we also think should be overturned. Thank you, Judge.
Thank you.
I believe I have all the remaining
All
arguments,
right,
so
well,
whichever the court would like
let's
to.
finish up topic 9 with your contention that the death penalty should be struck because it violates international law.
Thank you, Your Honor. So that motion is largely premised on the International Convent of, I'm gonna have to pull it up because it's the ICCPR. International Covenant on Civil and Political Rights. And so essentially the argument comes down to this. We have signed and ratified a treaty that would put, we think, additional requirements on what we would do if we're going to have a death penalty in this country, and obviously we have one. One of those is a requirement that we make sure that we're not arbitrarily killing people. And the other one is that people are not being essentially tortured.
My understanding is when the time that that convention was ratified with the understanding that to the extent that it is agreeing to anything, it is agreeing to afford the Eighth Amendment protections.
That's correct, Judge. And I think to some extent, what we're arguing is the Eighth Amendment and the ICCPR work together, and that we can look at these international obligations and the Eighth Amendment and say that they essentially are the same thing. That's why we talk about.
Well, I think you're looking at it from two different prisms. I think what the state is saying, to the extent that this covenant applies, which is a question about whether it's self-executing and all the rest, it only governs to the extent that the Eighth Amendment, apart from that, would have protected that situation. Whereas what I think you're arguing is that the Eighth Amendment must be read to be broader as to what international law would dictate.
I think if what we're saying is that the state would argue that we read the Eighth Amendment and that's what the international law must be, we're saying you have to read the international law to decide what the Eighth Amendment.
So you're having the international law dictate what the United States Constitution means.
Correct. And we are doing that on the basis of what the United States has said itself about the fact that they believe that they live up to these things, and the fact that we discussed the Charming Betsy canon, which is obviously a very old canon and typically is just about whether or not our statutes are in line with our treaties. But I think particularly in this case, where the United States has essentially said, we signed on to this treaty because we live up by these same standards that everyone else does, we can look at what the international community thinks about those standards that we said we also abide by when we're determining whether or not we're living up to the standards in the Constitution. And
Well, what they said specifically is that we think that we are living up to those, even though we have and will enforce a death penalty.
And I think, which is why we're not saying necessarily that the death penalty would be struck if it was done properly. Our argument is that the way that Idaho has its scheme set up, there are far too many statutory aggravators, and some of them are just big enough to drive a Mack truck through. And so just about every murder could be charged and have the death penalty attached to it. And so that doesn't require the narrowing that we've said we're going to provide, and it certainly doesn't live up to what the international community would expect from us.
Yeah, I understand the argument.
Well,
I'll be frank, it's falling about as flat as you would expect it to fall before our Supreme Court or the Supreme Court of the United States.
well, Your Honor, it's an argument, and it must be made, so
So you need to make a record.
thank you, Judge.
Your Honor, unless the court has any questions, I'm okay.
I don't. Thank you.
Thank you.
All right, let's talk about the contemporary standards of decency.
Thank you, Your Honor. So I think the main case for this one was Roper v. Simmons. Unless confusing it with Atkins, but essentially the court has said that when deciding what contemporary standards are in terms of what's cruel and unusual, that the court first looks at what the state legislatures are doing and then makes a decision based on its own determination of what it is it's going to be. But when we look at those cases, they also look at other things. They look at international law. They look at what religious organizations are saying. I mean, they're obviously looking for what's the consensus going on.
I think Idaho Supreme Court said is what we look at is legislative and governmental determinations and actions.
That I think I think that's Abdullah where they had said that, and I think that was partly because the way that it was. And in those cases, it seemed like the record that was brought up to them was somewhat sparse, and so hopefully we've provided more information than they had at those times. But in those cases, the number of states that still allowed the death penalty, I think, was around 35. And as the court, as we noted, that number has dropped somewhat precipitously since that time.
And those would be the legislative activities. I think what I was, I guess, taking issue with is the idea that they would look to what religious and other sort of non-governmental advocacy groups would argue or accept.
Well, I can only say that Roper definitely looked at international law. And if it wasn't Roper, then it was Atkins. But the one about children and whether or not they can face the death penalty, they definitely looked to international law. And so I don't think there's anything that says that the court can't look at whether or not organizations have moved against the death penalty. We are becoming somewhat alone in the world in terms of continuing to make use of the practice. The number of states that are still doing it is shrinking. And so when you look at that total fabric, it's our contention that we've reached the point where the death penalty really ought to be abolished. And so that is our contention in this case. Thank you, Judge.
Thank you, Your Honor. While Roper may have looked at some international law, I think the Idaho Supreme Court has really narrowed that window. First in Abdullah, they said, therefore, absent some legislative or executive action, a determination by this court that Idaho's death penalty statute is unconstitutional based on evolving standards of decency and public opinion is unsupported. So they're really looking in at that. And fast forward 5 years in the Hurston decision, 2020, the Idaho Supreme Court reaffirmed that view and then also said, quote, we continue to subscribe to the view of legislative bodies as the basis for determining a national consensus. And so, and the reason for that, they explain in Abdullah, is that courts just aren't good at taking a temperature of public opinion and what represents society's views. Now, looking at the states that have capital punishment, according to the resources both sides have cited, there's 27 states that still have it on the books. That's a majority. They've pointed out that there's gubernatorial moratoriums in 6 of those, which is true. But that means worst case scenario, there's 21 states that still have the death penalty on the books and can use it. And what the Idaho Supreme Court said in Hurston is that we're looking for a national consensus. And we're nowhere near a national consensus that the death penalty is somehow immoral or improper or indecent. I would also just note, it's not enough if what you're trying to show is a national consensus, it is not enough to just point to the fact that a state doesn't have the death penalty. You would have to show that the state removed the death penalty because that state believed that it was immoral or improper. So for example, if a fiscally conservative legislature just decides they don't want to fund the death penalty, but they have no moral objection to it, that's not evidence that there's some societal standard that would.
What do you take of evidence from a state who is not enforcing the penalty because, for example, an executive of that state is morally opposed to it and has the power to preclude it from being applied? Should that be considered?
So the Idaho Supreme Court did mention executive action, although in Hairston they seem to say the better picture is painted by legislative bodies. And I think part of the reason for that is because the executive, it can just depend on the administration that's in power at that moment. A perfect example of that is the United States. The death penalty is on the books. It's currently not being applied, but shortly before the current administration it was. And I think it's safe to assume that it will be again here shortly. The other thing you have to look at is why is the executive doing this? For example, the defense cites that Tennessee has currently a moratorium. True, but the governor did that because he said we need to take time to fix the execution protocol. That's not evidence of a national standard that the death penalty is wrong.
So in a state like Tennessee, are they still in the sentencing capital sentences, but just not carrying them out, or have they stopped even trying capital cases?
I can't answer that definitively for Tennessee. My understanding is that they still try them and impose the death sentence, but that it's just not being carried out. I know that to be true, for example, in California, juries are still imposing the death penalty. I know in Ohio, another state that they've pointed to where there's a gubernatorial moratorium, there are 30 scheduled executions in that state. They keep getting pushed back, but the reason they're getting pushed back and the reason for the moratorium is they can't find chemicals to do lethal injection. Again, that's not evidence that there's some standard of decency that's keeping them from doing this. They just can't find the chemicals to do it. So I think...
Well, I mean, you could imply that the standards of decency as applied by the pharmaceutical companies who refuse to take part in it is some measure of that.
Potentially, yes, but I think, again, going back to the Idaho Supreme Court's decisions, we're looking specifically at executive and legislative action. And the fact that the legislature or governor is saying we would do this, but we can't get the chemicals, is actually evidence that they still support the death penalty. So I think no matter how you read the numbers, we're not at a place where there is a national consensus that the death penalty is indecent. And so we think the court should continue to follow what the Idaho Supreme Court said in both Abdullah and Hairston and reject their motion. Thank you, Your Honor.
Buttle?
Just briefly, Judge, I would caution the court trying to figure out why it is that a particular state either dropped the death penalty or imposed a gubernatorial moratorium. I mean, I think that these things are complicated. That looks an awful lot like trying to figure out from legislative history why something occurred. Half the time, what you see in the questions doesn't necessarily tell you what the legislature had in mind when they finally voted. And so I think the first step, as the United States Supreme Court has set it out, is just to look at the numbers. And then after that, the courts can consider other things.
Or 2021, if you take into account moratoriums. How, I mean, certainly more than a third of the states, how does that represent a consensus?
I would argue that the consensus can also come from the trajectory. So the fact that so many states dropped the death penalty within the last 10 years, and that appears to be the direction that things are going, is something that the court can take into account. I also note a lot of these states that have death rows and don't have a moratorium still aren't actually executing anyone. And so the actual number of executions in the states that are actually executing anybody is less even than that. I think it's something like 13 jurisdictions that are actually doing executions. So anyway, for those reasons, Your Honor, we are asking that you strike the death penalty.
Thank you. All right, I think that leaves us with your motion to trifurcate the proceedings and to apply the rules of evidence in the penalty phase.
Right. So, Your Honor, I tried a case via the trifurcated method. It went smoothly, and we moved this court to do the same thing. If it's not trifurcated,
Which case was that?
that was Renfro.
Which one?
Renfro. If it's not trifurcated, what happens at the in the penalty phase is the state would be putting on both statutory aggravators and non-statutory aggravators. I think the state's argued that some of those things.
Isn't there a post-conviction proceeding in which it's alleged that that is ineffective assistance to allow the trifurcation because you make the jury decide about whether or not an aggravating factor is there in the absence of any mitigating evidence that might otherwise affect their decision?
I'm sure there is. But I can't say that I agree. Because from a jury's perspective, I mean, you have to realize that these are people who have been pulled in, they don't have legal training, and now you're asking them to make a bunch of different decisions at the same time. And as we pointed out, I mean, we can go back and forth about, what's the, if you don't trifurcate, you're going to put on the victim impact during the penalty phase with everything else, right? And so whether or not there's even a statutory aggravator is now going to be influenced by all of the things that are emotionally really powerful. And so, I mean, we can go back and forth about, who does that prejudice. At the end of the day, a trifurcated proceeding is just simpler for a jury to do their job. They have to be able to make a decision about statutory aggravators to even have a death penalty in a particular case. Being able to do that with just a standalone, do these things actually exist first before you start to get into the mitigating and aggravating? I mean, you can put on some mitigating depending on what the aggravator is at the aggravating portion of the case. You can talk about future dangerousness and things like that, assuming that the court decides to let it in. But if you don't do it this way, what you risk is that a jury is going to be influenced by non-statutory aggravators, victim impact statements, and on those grounds, say yes to one of the statutory aggravators. And you also are telling the jury, these things you have to find beyond reasonable doubt, but these things you don't, and do all of that at the same time. And I mean, the studies have shown that juries really want to get these things right, and they really want to follow the law, but oftentimes the instructions that they get aren't really that clear. And I think adding to their burden by cramming it all into one hearing, it's unnecessary. The court has the ability, I think under Rule of Evidence 106, to let them do the function that they're supposed to do with the statutory aggravators, and then that way they can make that decision. And if they don't find any, you don't even have to do the next part. But if they find one, then you open it up into the state's case in aggravation and the defense case in mitigation. In terms of using the rules of evidence, as we pointed out, a number of courts have said, confrontation clearly needs to be able to apply. You have discovery that needs to go out. Rules of evidence are helpful, and they're certainly helpful when you're talking about the statutory aggravators themselves. And that's an area where if you're trying to make a accurate determination of whether or not those things exist such that you can have the death penalty, the use of the rules of evidence is, I think, can be detrimental to both sides if you just kind of allow willy-nilly whatever to come in. So for the other reasons we put in the brief, Judge, we are asking the court to consider doing this as a trifurcated trial if it gets there. Thank you.
And Your Honor, just to briefly address the point about the confrontation clause and the rules of evidence. The defendant has fairly acknowledged in his brief that the Idaho appellate courts have issued binding precedent that's contrary to their argument today. The state's not going to belabor that point. I think the case law is clear, and the state briefed that. As to trifurcation, the defense has yet to lay out what exactly this process would look like. And what I mean by that is, at what point it appears, although the defense has not explicitly stated this, that they would encourage this court to adopt a procedure where the state puts on all of its aggravating evidence for all of these statutory factors, and the jury then goes to deliberate on these factors without hearing any of the mitigating evidence. Now, this is very concerning, and particularly, the state briefed this. You take the propensity aggravator, where the jury is tasked with determining whether or not the defendant's going to pose a continuing risk, to send them back to deliberate without allowing them to hear evidence in mitigation. That's very concerning to the state about what that might do to, for example, the appellate record. And I think that post-conviction proceeding in the Renfro case really highlights the concerns with this procedure that they're asking the court to adopt. As to the assertion that this is simply too confusing to the jurors, the court will instruct the jury on what the law is. And as we've argued on these other motions, the court can't just start with the assumption that jurors aren't going to follow the law, that it's simply too concerning or too confusing for the jurors. The jurors will receive instructions. They are presumed to follow those instructions as a matter of law, and the court should assume that these jurors will do as they're instructed. And unless the court has any questions for me, that's all I have. Thank you, Your Honor.
Well, for the record, it really wasn't that confusing. We had the propensity aggravator in that case. We put on evidence that pushed back against that at that point in the case. It's cleaner from the jury's perspective. It was cleaner from our perspective. I don't think we even argued about it. I think the state just went along with it. And I thought it went pretty well. And I definitely want to push back on the idea that, we have a tendency to have these tautologies in the law where we say, well, the jury is great and they'll figure it all out, and so long as we tell them what to do, then they've done what they were told. And there are studies that show that's just not accurate. I mean, there's the jury project. You can read what it's like for people to go through these things. And when we're talking about whether or not somebody's going to be put to death, I think it's important that we really think hard about how these people are going to make these decisions. If we're going to do a normal, just a penalty session, I definitely think it's something that's going to require some additional instructions. I know the Supreme Court just recently updated a lot of the ICGs, which is great, something that I've been advocating for. But there are additional things that I think are going to have to be told to a jury so that they can understand how that would function. And if you trifurcate it, it's going to make it simpler for them to understand, okay, you've now found this person guilty. Now you're going to be determining whether or not one of these statutory factors exists. This is what they are. This is how they're defined. You have to find this beyond a reasonable doubt. The state's going to do an opening statement and a closing. They'll put on evidence as to whether or not these things exist. This defense is going to come in, question those things, put on their case why those statutory aggravators don't exist, and you're going to make that determination. If you make that determination, then we get to a sentencing proceeding where the state's going to be able to put on any additional aggravators that it wants to put on, and the defense can then put on any other information that they have that's going to be in mitigation. It works, and it worked, regardless of whether or not the SAPD doesn't agree with me. I'd ask the court to consider it. Certainly if the court decides not to do it, we'll have lots more conversations about how best to do that.
It's an intriguing idea. The concern, of course, is the desire to do this case once and not twice.
I understand.
And there's a protocol that has been approved by the appellate bodies versus the one that you're proposing now. And so that's always in a trial judges who tend to be fairly risk averse difficulty.
Yes, sir. Well, thank you.
Thank you, sir. All right, my dance sheet indicates that we have covered all the topics. Did I miss anything from either of your perspectives?
Not from the state, Your Honor.
No motions, Your Honor, but I think Ms. Massa has one thing.
One housekeeping.
Sure.
Judge, we submitted Professor Cover's PowerPoint and her data. We filed it this morning under seal. We had a conversation that you thought that that should probably not be under seal, definitely with the PowerPoint. We have no issues there. It was filed with one thumb drive. We discussed letting us look to see if there is victim information that needs to be redacted. So what I'd like your permission to do is file an amended Exhibit A, and if we'll get things redacted. The one that's filed and you are inclined not to seal, I just don't want it to get out there before we've had an opportunity to review that and redact names.
I'm assuming the state doesn't have an objection to that.
No objection, Your Honor. Thank you.
All right, and that's fine, counsel. Let me address, that brings up a good point in terms of just process for filing matters that need to be sealed in some way or the other. Because as we know, the rules for filing require them to be physically filed if you're seeking to have them filed under seal, which causes some difficulty for most of you who are not in the Treasure Valley area. I think perhaps the best way to deal with this is if you're going to file something and there's some portion that needs to be under seal, if you would provide a redacted and an unredacted copy. So for example, I think the defense filed a recent request for discovery and had an exhibit attached that they felt should be sealed. I'm assuming that's why they requested it to be sealed, was because of the exhibit. So you would file that one with, the exhibit just being a blank page saying redacted, and then provide the court and opposing counsel a courtesy copy of the unredacted, and then you can file the unredacted when you are here to get it filed under seal. And then we can let the public have the redacted version so that we, as much information as we can make public, we can.
We'll do it that way. Thank you.
That works for everybody.
Thank you, Your Honor.
Else for today?
Nothing else for today. There was a motion filed that got placed under seal that the court was going to schedule.
Is that about your jury voir dire procedure? Yeah, I think that's probably more appropriate to take up as we get closer to the pretrial than anything, because it really deals with essentially what is and isn't allowed in voir dire and in questioning. So I think it's just a little early in the game yet to get to that, from my perspective at least.
Your Honor, the only thought I have about that is perhaps talking about that may cause the court to think we should begin voir dire maybe a tiny bit earlier than is currently scheduled.
Well, we can, I think our pretrial is in May, correct?
I don't recall.
I think it's
I would
in
trust the
May.
court on that.
And our voir dire is set to begin in August or late July, I can't remember. So I think we have some flexibility there, and perhaps we'll address it at another hearing before the pretrial. I just thought with the number of motions we had today, that it was probably something we could save for a later day.
Fair enough. Thank you.
All right, anything else?
No, thank you, Your Honor.
So that I'm clear on the record with respect to why I sealed that, I don't think you submitted that intending it to be sealed originally. The reason I did is because it had in there specific questions that can and can't be asked of folks who are being questioned for voir dire. And because of the extensive publicity here, I don't want to unnecessarily limit our available groups of veneermen because they've read something about what questions to specifically expect to be asked. And so that was my reason for sealing that. Okay. All right. Well, thank you. Everybody have safe travels back. I will take the matters under advisement and and issue written opinions forthwith. Thank you.